Good morning, sir. All right, we're ready to hear from the appellant. You may come up here to the podium. Yes, thank you. And are you Mr. Derrick Strode?
I am Mr. Derrick Strode.
Good morning, sir. You are the defendant and the appellant in this case, and I understand that you are representing yourself, but you're not an attorney.
Yes, sir.
Very good. Well, you have the absolute right to represent yourself, and we're glad to have you with us. Please understand that we may or may not ask questions. They don't indicate how we're going to rule. It's just a question that we want an answer to.
Okay.
But do you wish to save any of your 15 minutes to respond?
I'll save 5.
All right. Then the clock will be set for 10 minutes.
It's quick.
Very good. Please proceed.
Yes, at this time, yes, I am Derrick Strode, pro se appellant in this matter, and I'm asking the Honorable Court to handle all of this. This is something I've been dealing with for years, even prior to when I initially created the loan years and years ago. When I was in the previous trial courts across the street, I wasn't treated fairly, it wasn't handled properly, which is the reason why that I appealed. It was said on the record, which you guys have the video of, that Judge Brothers, which I really like him, so it's nothing against him, I really like Judge Brothers. But anyway, he said it was gonna be like a clear case because it was like a debt-related case and a breach of contract. But I showed a clear breach of contract at the beginning and they forced me to continue, being that we had a binding arbitration agreement. And so I never ever should have entered into court. Furthermore, I had shared with Judge Brothers, which he also said that anything that I give him, he'd have to give to them as well. And it would go on as an exhibit, but they didn't put it in as an exhibit, which was a credit report showing where the account had been closed. With the account being closed, a 1099-C should have been issued to me. The guy that he had as a witness, that was the manager of Republic Finance, said on record in the court that they had wrote it off as a loss and it had been charged off. You can't double collect. Like, there are actual laws, and I have the case laws where it supports that, some of them which I've already put in the brief and so forth already, so I don't need to be redundant. Then on top of that, just that alone, the court lacked subject matter jurisdiction because of this, knowing that with what Corey Owens had already submitted, which one of his exhibits was the actual contract that I had from Republic Finance, which stated under no circumstances were we ever to go to court. Now, he recited things from the Arbitration Association, but that was never expressed or ever communicated or made plain with when I made the actual agreement with Republic Finance initially. What I also even submitted to this court, and I did it first across the street where I wanted them to correct the record, because even though he poses as representing them, every single communication they always send me has the cover letter saying that we're a debt collector. This is an attempt to collect the debt, separating themselves legally so that they don't get in trouble for trying to pose as one in the courtroom. Now, he puts it in these 4 corners, so doing all this research, representing myself, understand the 4 corners of the law, that makes it where it doesn't count in that. But clearly in everything, I had put this information out there to show that they don't hold any kind of position. I even asked him to produce anything showing a connection with them, being that it had been charged off. Even also Republic Finance, with their communication, they have said that this is for entertainment purposes only. We're not attempting to collect the debt when they even communicate with me. So all of these things should have never allowed this to even get over here. But I have to defend myself because I'm being treated unfairly.
When your case came on for trial before, I think you said Judge Brothers.
Yeah. Good guy.
Did Judge Brothers mention to you that you had the right to arbitrate?
Yes, yes, he did. And what I had furthermore told Judge Brothers was that just as clearly, yes, I had the right to arbitrate, but by never being given the opportunity to arbitrate was clearly a breach of contract within itself. So I requested for dismissal of the case in its entirety, which he ruled
Did
against.
Judge Brothers offer you the opportunity to arbitrate or instead to go forward with the trial?
Yes,
And
absolutely.
you chose to go forward with the trial?
Yeah, well, I chose and asked him to, I made a motion to dismiss, which he denied, but being that he denied it, I chose to continue, and because he said I could submit the evidence that would support that or the defense and so forth along, which is what I did.
Was the first instance that you raised to a court as opposed to the creditor here, the issue of arbitration, was it the day of the trial? Was that the first time that you raised it to a court?
It was, I believe that was on August 1st of 2024.
So before the General Sessions Court, you never, I know you asked for continuance at one point in the Sessions Court,
A couple times.
but at that stage, you never informed the General Sessions Court, hey, this shouldn't be continued, I want to arbitrate.
No, I did not, because I had never even really dug that deep into the contract until I knew that it was going to be like trial time. Because this whole time, like, I'm a pastor of a small church, so this whole time from June 1st, which I commented this is on the record in the video thing, that from June 1st to July 31st, I'm working with kids. That's what I'm doing. I'm not going to tell the kids, well, no, I need to be preparing for a case for somebody that I don't really owe, so you don't have anything to do for the summer. So I didn't really deal with it until after then. Now, even when August 1st came, which was literally the day after the last day, no breaks, I told Judge Brothers I just need like a week or two. I don't even want to be pushed out far. I don't want to prolong this because I don't like coming to court. This is a waste of my time. And they wouldn't do it. They made me continue. After that, when they finally had the ruling, back on December the 6th or whatnot, this was literally, I mean, I got all the proof you could ever want to see. Literally, I just kissed the eldest member of our church on her forehead, deceased. I come in there and I tell them that I'm leaving from the hospital. I'm traumatized. This was like my biggest supporter. A woman I've known like a granny to me. I tell them I'm just leaving the hospital from now seeing her dead. They wouldn't give me a continuance then. But what it says in these proceedings is that should have never, ever happened. Owens versus National Health Corp. 263 SW 3D 876 Tennessee 2007 courts made clear due process includes fair opportunity and mental readiness to participate. That was utterly abandoned. So all of these things, and it being me being pro se, because I couldn't afford, an attorney, and I was fine with that. And then on top of that, they're damaging me credit-wise. They know that the account is closed. In the meanwhile, they keep putting on my bureau as if this account is open and that I'm not paying every month or whatnot. But they know that the account is closed. And this stuff only started happening when we continue and go into court. So they're intentionally harming and damaging me. I told them also at the beginning of the case, I was between on my housing and so forth. So me having a certain credit score is very viable, whether or not I want to get a place to stay and so forth. They still do this and they attack me. So other opportunities that I could have, I couldn't have. So I'm being willingly damaged when they already know. So it's traceable harm. It's like a fact. And these things are still being carried out all along the entire time. They breached the contract and they decided to charge it off and write off their debt. If it was still open and it was still there, then it would be something that I would need to handle myself. But once they decided to write it off with the IRS, it's actual abandonment if they didn't send me a 1099-C within 2 years, which they did not. So they did not do that also. They never ever proved relationship that they actually have to do that. And he actually, every communication that they send to me, they clearly express that they're a debt collector, even though on record, under oath, under penalties of perjury, he'll say that he's representing them directly and it never happened, even though his own witness said that it was charged off and that they had wrote it out for a loss. So, in summary, I want the trial court to reverse the decision completely. I want to be adjudicated. I want them to vacate the judgment, and I want all attorney, court fees, anything like that to be assumed by the Michelle Reynolds Law Group. And I also want to seek damages for the harm and so forth that I've endured as well.
All right. Thank you, Mr. Strode. We will hear from Mr. Owens for Republic Finance, and after he's through, we'll ask you to come back up to respond.
Sure.
Right,
Since I have 1 minute left, I got 6 left.
You'll have 5. You'll have 5, but fair request. All right. Good morning, Mr. Owens.
Morning, Your Honor. May it please the court, Corey Owens from the Rutherford County Bar, representing the appellee, Republic Finance, in this matter.
Did you beat the truck wreck, or did you come a different route?
I narrowly beat the truck wreck, Your Honor. I was hearing you all say something about that, and I was like, I must have got around it because I got here a little early. So
You didn't cause it, did you?
I did not cause it, Your Honor, to my knowledge. I mean, you know, they move fast and quick on 24 all the time. So, but it wasn't me. Your Honors, this is a case about a breach of contract. Mr. Strode, the appellant, had an agreement with my client. My client loaned him money. Mr. Strode used that money, and then Mr. Strode failed to pay those monies back. And so under the contract, because it was breached, they proceeded with a lawsuit, and my firm represents Republic Finance in Middle Tennessee areas. And so we have an agreement with them that if they have a case where somebody has breached the contract, they send it to my office for representation.
And so was it your office that was sending communications with the debt collector disclosures?
Yes, Your Honor, because under the FDCPA, because we are collecting debts owed to another, my client, they state that we have to put those disclosures on anything that we send out. And it's as a precaution, but also because my office does collect these debts, and not everyone in my office is an attorney, and they do speak to individuals as well. So we also make those disclosures over the phone. Originally, it was more of an abundance of caution, but they've since the FDCPA have come out and said that attorneys are subject and law firms are subject to the FDCPA, or excuse me, the CFPB has come out and said that the attorneys and law firms are subject to the FDCPA. So we therefore comply as much as we can, being a small firm. And included in that is the disclosures on just about every document we send out that this is a communication from a debt collector, and any information obtained will be used for that purpose. But in this case, it's a situation where we had a judgment. We had an initial hearing in general sessions. It was continued at Mr. Strode's request. Mr. Strode didn't appear on the continued matter. A default judgment was entered in general sessions, and then Mr. Strode appealed as his right, timely, to the circuit court. And then in circuit court, when we came to the day of hearing, Mr. Strode did ask for a continuance with no other notice. Judge Brothers did deny that request, and then Mr. Strode did request arbitration in the preliminary hearing. Judge Brothers heard that request, and he took it back into chambers for review, came back, and he was prepared to give arbitration to Mr. Strode and order arbitration. Unfortunately for Mr. Strode, that wasn't what he wanted. He wanted the case to be dismissed, and then for us to proceed in arbitration. Typically, that's not how arbitration works in my experience, even if a case is filed.
So the first request for arbitration then was an oral request made on the date of a preliminary hearing or a date of trial?
Date of trial, Your Honor. So it was the same day that he referenced, August 1st, the date we had the trial. And so Judge Brothers took it under advisement, and then Mr. Strode stated that he wasn't sure if that's how he wanted to approach the situation.
Are there any filings in circuit court beyond the notice of appeal from Sessions? Were you running on the warrant, or was there a new complaint filed or anything?
But we were running on the warrant. I did file a brief statement of facts that included some of the documents, but like the contract and things like that.
So was this the local pretrial brief? Is that what you were doing?
Yes, Your Honor.
Okay. And then what about on behalf of Mr. Strode? Were there any filings by him in the case?
I know Mr. Strode has filed several things on the case. He never filed any sort of notice for arbitration. if that was what you're trying to get at. We never received any request for arbitration to my office or through the court, except for the day of trial, that oral motion by him.
Under the contract, arbitration was optional, correct?
Yes, Your Honor. In Section 3 of the arbitration agreement, it gives the option to either party to file suit under the contract. He could have filed suit against Republic, we could have filed suit against him, and then at that point, either party could still elect to go to arbitration. Due to the costs of arbitration, a lot of times we have found that it's cheaper not only for my client, but also for the defendant and the appellant to not proceed with arbitration, to go forward with general sessions, and then we work out agreements and settlements and things like that that ultimately could lower the cost, because
I think a lot of parties are discovering that's the case, that it's really not any less expensive to go through arbitration than it is to just go to court.
yeah, unfortunately. In a matter like this, where we have the contract was breached, and that is pretty straightforward as far as, there was non-payment on a loan, and this is how we typically handle these cases with my office. And so Judge Brothers did take his request for arbitration seriously. He took a recess and then came back and stated, was willing to grant the appellant's request for arbitration. At that point, the appellant was still unsure what he wanted to do. He gave another recess for lunch for us to talk and negotiate, and that occurred, but the negotiations stalled. And then that's when we came back, and Mr. Strode presented his motion to dismiss, with Judge Brothers denied. And Judge Brothers, looked at him and asked him in court, how do you want to proceed? And Mr. Strode stated, and I quote from the record, "I'm willing to have it resolved here in court today." So at that point, my client's position on that is he waived openly in court the right to arbitrate, and had the case decided in circuit court that day. This is a situation where we had the trial, judgment was awarded for my client, and Mr. Strode is unhappy with that. He's unhappy that he lost this situation, and he is continuing to exercise his right to prolong this situation instead of trying to resolve it, and we could have resolved it in multiple ways if he would have contacted our office.
Is this arbitration clause governed by the Federal Arbitration Act or the Tennessee Uniform Arbitration Act?
I believe it is. It complies with both, Your Honor, because my client is in multiple states. Now, I do know that the arbitration agreement calls for the AAA, the American Arbitration Association, to arbitrate the agreement.
But Republic Finance is located in multiple states.
Correct, but they do have a registered agent here in Tennessee. They are a Tennessee corporation as well.
Okay.
And so if Mr. Strode, the appellant, wanted to arbitrate, we would have left court the day of trial and we would have went to arbitration. He chose not to do so. Now, and we get to the talk of the charge-off. The charge-off is a term of art used by the SEC for loan companies and banking companies for loans and accounts that aren't bringing in money payments. And I'm no SEC expert. I just know what my client has told me and what they have to comply with. So what they've told me is the rule is if they don't bring a full contractual payment in on an account or loan within 6 months, they have to charge it off of their books as not making money. That doesn't mean that they write it off. That doesn't mean that they say this debt is forgiven. It just means it goes to a profit and loss statement, and they try to collect the loan still because they still owe the debt. It was undisputed testimony in the trial that my client never issued a 1099-C to Mr. Strode. Also undisputed that the debt was still owed. Mr. Strode even stated in court at trial that he still owed this debt while he was testifying. Your Honors, this is just a simple matter that, he also indicated that there was a subject matter jurisdiction issue. I don't believe that's the case. Mr. Strode resides in Tennessee and in Davidson County. The contract was signed in Davidson County, and which makes the appropriate breach suit filing in Davidson County General Sessions Court as the original jurisdiction. It was also under the $25,000 threshold, the $25,000 threshold for General Sessions. So I believe that General Sessions Court was the proper venue and for the subject matter jurisdiction in this case. Ultimately, Your Honor, we are requesting that this court affirm the circuit court's decision and allow my client to pursue with collections on this matter, whether we resolve it with Mr. Strode or involuntarily. This is a situation where Mr. Strode continues to appeal and exercise his rights, and that's fine, but it's just to prolong my client from getting this final judgment and prolong collection of this judgment.
Yeah. I want to make sure that I'm clear, that I understand what act you're saying that this contract would be, the arbitration provision would be governed under. You said Republic Finance has a registered agent here, but are they a foreign corporation that are authorized to do business in the Tennessee?
Yes, Your Honor. I believe they are a Delaware corporation.
I see. Okay. All right. That sort of makes it clear. So we are probably under the Federal Arbitration Act then. Okay.
Probably more so, but my understanding is that my client always tries to comply with both state and federal law in every aspect of their contract as much as they can.
Okay.
And that's all I have, Your Honors.
All right.
If there's no further questions.
Thank you, Mr. Owens.
Thank you.
Mr. Strode, the floor is yours. You have 5 minutes to respond to Mr. Owens' statements.
All right. Clearly, it says on the arbitration agreement, first off, with one of his statements, he said that it was an option. It says at the very beginning on Exhibit A, page 3, where it is titled Arbitration Agreement, that if not settled by mediation, will be resolved by mandatory binding arbitration. It wasn't an option to do. This was supposed to be the only way that it could be done. To even suggest that this is something that I want to prolong as if I have time to come in here, do research, do all these things, prepare to be in court, make sure I say everything right, do everything right for something I shouldn't be defending is crazy and insane to begin with. I don't want to be here. I feel that I'm being damaged all the way along the way. What he was speaking of as far as with a charge off or just writing on the profit and loss, you can't even do a profit and loss statement unless that's also prepared to go to the IRS. But even furthermore, back on the dockets when it was in the trial court, I believe it was filed, okay, exactly, filed February the 7th of 2025. Even though they didn't include it when I wanted them to correct the record, I have the actual credit report where it says collection charged off. Like, this wasn't just a thing that they were saying internally. This is something that actually on the credit reports it was reporting. Even more so than that on the contract and some of the communication, which I also included in that same thing. It says that they're a Virginia company as far as subject matter jurisdiction. Then even on top of that, what it says on the credit bureau, when it gives you contact information to contact the company, Republic Finance, it says that they're in Louisiana. So none of these things represent Tennessee. And what it is that's been going on, in my personal opinion and observation, is that Republic Finance is trying to double dip. I don't have the same account number with them, but I even have in the same thing that they wouldn't let me send, that when Republic Finance said that their office had closed, that it went to another office, they said this is for informational purposes only. Notice is not an attempt to collect a debt or demand for payment. This came straight from Republic Finance. So to say that like I'm prolonging something for them, Republic Finance doesn't even think that I owe them. And on the thing of asking for arbitration, I never asked for arbitration to begin with. I simply pointed out that a clause was violated that meant that it was a breach of contract. Judge Brothers took us on about an hour and a half recess to research it. He came back to find out indeed that yes, it should have been arbitration, and asked that I wanted then. I said I wanted to be dismissed because if you believe that clearly there was an arbitration agreement that didn't happen that should have, you have to also realize that this is an actual breach of contract. He denied that motion to dismiss, so I had no choice but to proceed, or either to let them do something that should have been done a year or so before this ever even happened. And that wasn't the case. Even when he was making a reference of me saying on record that I owed, that's out of context. I owed it at the time when the loan was actually live, before it was charged off, before the account was closed. I never, under any circumstances, said that I still owe them now, because they had chosen to write the debt off. At that point, I got to deal with it credit-wise or with the IRS when they give me the 1099 cancellation of debt. I prepare taxes. I understand the stuff that he's saying that he doesn't understand. I know how that goes, because that's what I've been doing for the last 15 years. So this part was never done. After 2 years, that's abandonment anyway. So I never said under any circumstances that, yes, I owe this current debt that we're in here on court together for. I did when I created that loan, and the reason that I couldn't pay it, they were closed, but that's nor here nor there. They still chose to close it. They did not offer mediation or arbitration. Actually, when I called them, which is on record on the video as well, they said it's out of our hands. It's nothing that we can do. So they breached the contract in that moment before I'd ever even stepped foot in court, because they never offered mediation or arbitration. They said it's over to the law firm, which AKA, and there's another portion on it when we were on recess and we actually talked, to when he told me, him specifically himself, he said, hey, you don't want me to make any money out of it or whatnot? I'm like, dude, you can't make money off of me and get a commission off of me just because you're spending your time trying to grab for debts. He admitted what he was in the hallway, and when I began to tell Judge Brothers that, he abruptly stopped me and said, I can't know what you guys were talking about. I'm like, even if he's clearly telling me what he really is outside of the courtroom, just not when he's under oath, so no, I never said that this was that. I never asked for arbitration at that time to come. I was telling them that the contract was breached. So for this reason, and for me having to go forward in traumatic experiences, no, this should be done out. That's my time.
All right. Thank you, Mr. Strode.
Yes, sir.
Thank you, Mr. Owens, for your arguments this morning. Mr. Strode, we will take this matter under advisement, and a written decision and opinion will be prepared, and the clerk of the court will send that to you and Mr. Owens. Thank you. Thank you. All right. Call the next case.